Hello everybody, it's Gina here from Will Written, future-proofing your family and your finances through the magic of estate planning. Today I'm going to address the question of what would happen to your business if something were to happen to you. And I'm also going to explore the 4 key pillars of wisdom that every business owner needs to be aware of when they're making long-term decisions about their estate plan for the benefit of themselves and their families and their business. So let's jump straight in and think about what's the worst things that could happen to your business if something were to happen to you. So first thing to consider really is what would happen if you were to die, and to die without a will. Now, the consequences of that depend very much on the structure of your business, whether you're a sole trader, whether you work in partnership, or whether you have a limited company. If you are a sole trader, the situation is quite straightforward. Your next of kin will inherit your business lock, stock and barrel automatically. Who your next of kin is depends on the intestacy rules, and it can be your spouse, it can be your children, it can be your parents, it can be your siblings, it can be more distant relatives, depending on your family circumstances. If you work in partnership, unincorporated, the situation is a little bit more complicated and a bit more challenging really for your colleagues, because technically, according to the Partnership Act, an act of parliament that goes back to the 1800s, that automatically results in your partnership being dissolved. So effectively that means that your business ought to be wound up. All of your outstanding invoices need to be settled, your bills need to be paid, and any remaining monies need to be divided up between your continuing or living partners, and your portion needs to go to your next of kin as appropriate. If you are trading as a limited company, then what you actually own is your shares in the company, and those shares are inherited by your next of kin. Now, in any of those circumstances, however, whoever inherits your business in whatever form also effectively inherits your job. They inherit the responsibilities that you used to fulfill during your lifetime. And that can obviously be quite a challenge if the next of kin involved is a child or somebody who doesn't really have practical knowledge of your business and the way that it's run. And if you have colleagues, they've suddenly by default acquired a new colleague who doesn't have a clear understanding of the business, and they've got a whole host of new challenges that really they never needed to address in the past. So yeah, potentially quite a headache for everyone involved. The other difficult scenario to think about is what would happen to your business if you were incapacitated, if you were rendered unable to make the decisions that you've typically made in your business, but you're still with us. That is potentially more of a problem even than if you pass away, because if there are no existing arrangements in place, potentially your entire business has to grind to a halt. Because if there are no arrangements in place, somebody is going to have to apply to a judge in the Court of Protection for permission to manage your affairs, including managing your business for you. And that process is expensive. It's a couple of grand plus, and it's very long-winded. You're talking a minimum of 6 months, very often up to 12 months, and thereafter there's lots of interference and lots of obstacles from the Court of Protection on a day-to-day basis that will need to be dealt with. So yeah, some really difficult consequences if something happens to you, whether you survive or not, if you haven't made appropriate arrangements in advance. So it is important, if you're a business owner, for you to put an appropriate estate plan in place. Now, when you're thinking what goes into that estate plan, there are 4 pillars of wisdom I refer to that you really need to consider very carefully. The first and most obvious one is choice of business executor. So that is somebody that you would put in your will, that you would name in your will, who would take over responsibility for your business affairs in the event of your death. Certainly it can be a close family member or your spouse if you feel that they could address the role of running your share in the business with confidence and competence as well. But if not, then you possibly need to cast your eye further afield. You might want to consider appointing your accountant, or perhaps your solicitor, or perhaps a colleague either within or outside your business that has the right skill profile to be able to make both long-term and short-term decisions in the best interest not only of your family but also of the business. And they have a range of options available to them to come up with the right decision in all the circumstances. They can manage the business themselves, they can appoint managers, they can institute an orderly wind up of the business and extract the cash from it for the benefit of your family, or they can allow your colleagues to buy out your share as appropriate, and they can handle the negotiations in that regard. The second pillar of wisdom is to think very carefully about making a lasting power of attorney for property and financial affairs, because that encompasses not only your day-to-day domestic financial affairs but also your business affairs if appropriate. And because you can appoint multiple attorneys, it means that you can appoint close family members such as your spouse and adult children to handle your day-to-day financial affairs, such as paying your bills and dealing with your home, etc. And alongside them you can appoint a colleague or an appropriate professional, the same person as would be your business executor, to be your business attorney, and they would fulfill exactly the same role if you were incapacitated as they would fulfill as your executor if you suddenly passed away, in safeguarding the business, safeguarding your family, and making the right short and long-term decisions for everyone involved. The difference being, of course, that on this occasion they're making decisions primarily about what's in your best interest, because you're still with us and you're very much the centre of attention in terms of your welfare. The third key decision to make is relevant if you run your business with colleagues, whether you're a partnership or whether you have a limited company with multiple shareholders. The important thing to do there is to make an appropriate agreement. So it could be a shareholders agreement or it could be a partnership agreement. And in a partnership agreement, that would override the default position that arises from that Act of Parliament from the 1800s that I was telling you about. And in a shareholders agreement, it governs the relationship between you and your colleagues as owners of the business. And the key provisions that you would want to put into that agreement, whether it's shareholders or partnership, is basically the same. It's all about ensuring that if you die or are incapacitated, the business can continue to trade with as little disruption as possible, whilst the value that you have built up in that business can come out and be provided to your family, your nearest and dearest, for their long-term benefit and maintenance and welfare. And underlying that agreement is the fourth pillar of wisdom, which is life insurance. You'll need to talk to a financial advisor about this, but there are types of life insurance that are specifically designed for owners of businesses. The premiums can be classed as business overheads, so offset against your tax bill every year and paid by the business, rather than you having to reach into your back pocket and pay for the premiums personally. And the proceeds of the policy actually go to your colleagues in the business to provide them with the funds they need to buy out your share of the business from your beneficiaries of your will or beneficiaries of your estate. What that then means is that your colleagues can continue to trade uninterrupted because they've bought out your share and they've got appropriate funding and haven't had to go cap in hand to the bank or to other lenders. And more importantly, a significant sum of money, of capital money, that's liquid, can come out of the business and go straight to those members of your family that need it the most for their long-term benefit. So yeah, those are the four big decisions that you really need to consider quite carefully when you're thinking about what's an appropriate estate plan for you and your family and your business going forward. Obviously, it's not something that you can just think up over a cup of tea in 10 minutes on your own, and a little bit of professional support is often very helpful. So do feel free to reach out for support from me here at Will Written. Give me a call or reach out by email. There's also lots of great sources of further information that you can read into on our website. I'll leave those contact details and the link below. It's always good for you to have just an informal chat with somebody who knows what they're talking about to help you to arrive at clear decisions that are the best for the circumstances that you're in, and come up with an individually tailored estate plan that works for you and your family and your business. So that's everything I need to tell you today. I hope that was helpful, and as I say, if you want to take this conversation further, take a look below for those ways of reaching out, and we can certainly have a chat. Lovely to see you again, and I'll see you soon. Take care now. Bye bye.